Thank you, Mr. Chairman. Inspector General Fine, you've said that you didn't find that any of the violations were deliberate or intentional, and yet you also report the issuance of blanket NSLs, which to me appear to be an effort to cover up what was recognized to be flawed issuance of these exigent letters. Given that NSL letters are supposed to be case-specific, the NSLs were a blanket violation of the law, weren't they? And how can they be described as unintentional or anything but deliberate?
Yeah. I think what you're referring to, Congressman Schiff, is issuance of what we've heard about of blanket NSLs in 2006. We haven't reviewed 2006 yet. We reviewed 2003 to 2005. We've heard about this. It happened. It passed the review period, and we're concerned about it, and we'll look at that.
Well, Ms. Caproni, in your briefing on the Hill last week, you acknowledged that when agents realized that they had been issuing these letters, these exigent letters, saying that subpoenas were forthcoming when they were never forthcoming, that blanket NSLs were issued as a way of basically trying to clear up or cover up, or in other words, make up for the failure to use correct processes in the past. Assuming those are the facts, Inspector, doesn't that show a level of deliberateness and intention that far exceeds what you've described in your report?
It certainly shows us concern. And what were they thinking? They clearly were not following the procedures. They clearly were not providing NSLs in advance or even quite reasonably soon thereafter. And it did give us concern. And there were a lot of people who did this. It was done as a sort of a routine practice, which is, in our view, completely unacceptable. But I think it is important for the FBI to look at this and to interview these people and find out what happened up and down the line. And we will be looking at it as well in 2006.
Well, even the false statements themselves, these letters that were, these exigent letters that said that subpoenas were forthcoming when they weren't. Let me ask you, Ms. Caproni, if a local cop in the city of Burbank, in my district, wrote letters to the phone company or went out and served letters on the phone company saying that federal grand jury subpoenas would be forthcoming because that local cop wanted to get information that maybe they couldn't get another way or couldn't get as quickly another way, and you learned about this practice, that cop would be under federal investigation, wouldn't they?
Congressman, I really don't know. I don't think you've given enough facts to say whether that would or wouldn't.
Well, a local police officer acting under color of federal law, demanding records that claiming a federal process that's non-existent, that wouldn't be an issue for federal investigation?
It would certainly be troubling, much as the practices that were taking place in the Cal unit are troubling.
Well, having worked in the corruption section and the U.S. attorneys in L.A., I can tell you it'd be more than troubling. You'd have F.B.I. agents assigned to investigate that local cop. It doesn't seem to me any different to have F.B.I. agents giving telecommunications providers letters saying that subpoenas are forthcoming when they're not. When did your office discover that these old New York form letters are being used to get information?
Yeah, sometime in 2006.
There's a report in the Washington Post indicates the head of the communications analysis unit, the same unit that drafted most of these letters, warned superiors about the problems in early 2005. Do you know anything about that?
I know what I've read in the paper, and I know that the inspection division is going to do a full inspection of this to see what exactly the unit chief said.
Well, I'm asking, beyond what you've read in the paper, and we all know what the IG is going to do. When did you first learn about the fact that the head of the unit that was drafting these letters had warned superiors? Do you know who those superiors are?
I don't know who he says he warned.
Were you warned by him?
No.
Do you know if anybody in your office was warned by him?
I'm not sure that I even necessarily agree that there was a warning. I know that there were, and I knew generally that there were some what I understood to be bureaucratic issues within that unit. That did not include...
You keep on describing these bureaucratic issues. I mean, I find an interesting kind of mix of acceptance of responsibility in your statement and denial of responsibility. You seem to accept responsibility for mistakes others made, but acknowledge very little responsibility on behalf of the office you run. It's primarily your office that is intended to advise the agents about how to comply with the law, particularly in an area where the courts aren't scrutinizing it, as you pointed out, in a process that lacks transparency. Isn't that fundamentally the job of your office?
That is fundamentally the job of my office.
The time of the gentleman has expired.